about a little bit about their past, maybe not their legal background, but something that we wouldn't know about them that would help us get to know them a little better. So they'll each have 2 minutes. We did, like I said, we put the names in the hat, and the order will be Chris Christensen, Judge Maribel, Judge Hammond, Tabitha Marsh, and Torshio Feaster in that order. And then from there on, they'll be jumbled with other questions. Dawn Weir, who is also a candidate for the judicial position in Davison, was unable to attend today. And so she will not be participating, but it is not because her lack of desire wanting to be here, but because of a conflict in her schedule. And with that, what I will do is just, again, give some background with respect to the etiquette to use. One, as Mike said, please use your Zoom etiquette. I would strongly suggest using speaker view on this because right now I'm showing on the full laptop 3 pages of participants. And if you really want to get a better appreciation for the people who are speaking, it'd be probably best at least have speaker view on. Second, while we do have our own set of questions, we're not adverse to taking questions from if we have time and if the questions are appropriate, to having questions asked from you, the members. What I would ask you to do is to utilize the chat feature on Zoom. Do not chat to all, simply chat to myself and Jeremy Piper. And then while Judge Nethercutt is going through the forum and moderating, Jeremy and I will go through the questions you ask, make sure that they are appropriate, make sure they don't they're not duplicative of what we asked. And then if we have time, we will have some of those questions asked as well. Given that, what I will do is I'll turn it over to Judge Nethercutt and let him moderate our forum.
Thank you, Mr. Brickley. I would like to start out by saying that I'm very proud of our Bar Association. We have talented lawyers, we have talented judges, and as we begin this forum, I'm also pleased with the judicial candidates. We have good candidates who want to be judge, and their selection will be difficult. I'm hopeful that this forum will be helpful to you, the legal profession, and others who might be watching this later on in voting in 2 weeks. Now, I'm going to go right away to the questions. And as Mr. Brickley indicated, we're going to go in one order to start, with each candidate giving a 2-minute introduction. And then as we go through other questions, I'll jumble the order of people who will be asked to answer. And in our beginning, it's you, Mr. Christensen. Give us your introduction of yourself for 2 minutes. I got my watch going.
Thank you, Judge. Well, everybody, as the judge just said, I'm Chris Christensen. I've been practicing here in Genesee County for 20 years. I grew up in the city of Flint. I went to all the Flint public schools. I graduated from Flint Southwestern. One of the things I really want to make sure everybody knows is that I'm not averse to hard work. That's how I went through college. I worked my way through college as a rough frame carpenter. I worked my way through law school as a superintendent building custom houses. And then when I opened up my practice, I focused initially on real estate and business litigation. But as everybody knows, sometimes you don't get to pick what your practice is. And so I had to practice a diverse array of different specialties, including child abuse, neglect, probate litigation, complex civil litigation, and criminal defense, including murders and life offenses. So I've had a very diverse background at circuit court. But one of the other things I want to make sure everybody knows about me is that I've been active in our community and active in our profession. Currently, I am a State Bar Board of Commissioners. I was just elected to my second term as a commissioner. There's about 45,000 lawyers in the state of Michigan. Only 32 lawyers get the honor and privilege of being elected to be a commissioner, and I'm proud to have been elected to my second term. I'm a member of the Burston Fieldhouse Board of Directors, which, for those of you who don't know, Burston Fieldhouse has been around for almost 100 years, providing a safe place to have recreation and classes in the city of Flint, and it's exciting to be a part of their board. I've been active at our local bar. In fact, this bar association, I was the president 10 years ago already when Tina first became our director. It was an exciting time for both of us because we had the big flood right then, and we had to deal with that during her first year and my year as president. So I've stayed active both in our community and in our profession. Currently, I am the president of the Inns of Court, which is a a group of local lawyers and judges that, oh, it looks like I'm about to get the hook.
Yep, thank you, Mr. Christensen.
Okay.
Thank you for speaking. Judge Marable, would you introduce yourself, please? Judge Marable?
You're still on mute, Judge.
I apologize. Can everybody hear me now?
Yes.
I can't hear another cut. Okay. Can you hear me now?
Yes, we can hear you, Judge. Go ahead.
As I indicated before we went live, I indicated I'm not going to be able to participate in all of the whole forum. I do have an opening statement to read, and I can answer the questions very briefly because I did not return the questionnaire, and I will explain that. Today, October 19th, is my mother's 88th birthday.
Yay.
She has become the matriarch of her family. I'm truly this long. She was born and raised in the Jim Crow era in Memphis, Tennessee, and she had to sit in the back of the bus. She had to drink from the colored water fountain. She could only go to the fair on colored day. My mother attended segregated schools, including Tennessee State University, where she met Herman Marable Sr. I'm sure that when my parents never dreamed on their wedding day, 2 months after their graduation, that they would have a son that would be elected as a judge in a mid-sized northern city. My parents were not even allowed to cast a ballot when they lived in Tennessee. My mother, Iris Jean Marable, taught me the importance of respect. That means showing respect to others and standing up for yourself in a socially acceptable way when you are disrespected. She also taught me the importance of family and respecting family ties. I've been on the judicial ballot in this county for 22 years. And I have always participated in this forum. And I most certainly wanted to make sure that I made an appearance here today out of respect. That being said, I'm going to be spending some time with my mother in a few moments, and I want to introduce to everyone. First, I've told the powers that be in the GCBA
The
that I
time
was
is now up for the presentation, Mr. Judge Marable.
candidates to fill out an 11-question questionnaire a mere 2 weeks before the election. I also suspect that things are not completely on the level in the way the GCBA has approached the run-up to this forum.
Well, your time is up, sir.
To my opponent's article being published in Barbeat this
Yes,
month,
please.
an article I submitted being excluded. As it was explained to me, someone forgot my opponent was going to be on the ballot when the article was published. I remain a skeptic. So I'm going to go ahead and answer quickly that were in the questionnaire. And if anybody would like the opportunity to ask me, I certainly would invite any and all of you to call me. I did list my number.
All right, you're out of order now. Your time is up. And what we're going to do is give the other candidates an opportunity.
You're muted.
Okay.
There we go.
The next candidate, I have a mute button that keeps.
Now we got you.
Okay, the next candidate that we're going to hear from is Judge Hammond, and you can introduce yourself, Madam, Your Honor.
Thank you, sir. Well, hello, everyone, and it is always wonderful to be here at the Genesee County Bar Association for our meetings. I think most people on this meeting right now know me and know me quite well. I've been involved in the Bar Association since I started practicing 12 years ago, you know, when I first started practicing, Ramona Sane, who was the director of the GCBA at the time, took me aside, actually took me to lunch, and Heather Bernash to lunch, and sat us down and said, you know, you have to be a part of this organization. It's important for your career. It's important for you to be able to learn from those who have been there and have done what you're trying to do. And it probably was the best advice I've ever gotten in my life. This organization does mean a lot to me. I am a past president, and I am the current chair of the Community Action Committee. I've also held various other seats at the Bar Association, but I think everyone too knows, you know, kind of some of the more interesting or different things about me, you know, my work with trauma-informed yoga with the kids at the Juvenile Detention Center. I'm pretty proud of that. And I'm proud of my work in specialty courts, working with families and juveniles who have issues that they need to overcome to become productive members of our society. So I look forward to today's event and the questions that are going to be coming. And again, thank you, everyone. Thank you, Judge Nethercutt. And thank you, Tina and Bill and Mike for putting this all together, and Jeremy.
Thank you, Judge Hammond. Our next candidate who will introduce herself is Tabitha Marsh.
Well, good afternoon, everyone. It's certainly a pleasure to have lunch with you all today. I'm attorney Tabitha Marsh. I've been an attorney in the city of Flint for a little over 15 years. Prior to being in private practice, I clerked for Judge John Godola. I also clerked for Circuit Court Judge Michael J. Thiele as well. I'm a native of the city of Flint. My family has significant and deep roots in this community, from my grandparents and parents working for the UAW to my parents and grandparents working at Hurley Medical Center. I too am a very hard worker. I think my life story bears that out, from being a teenage parent and graduating as valedictorian at the top of my class in high school, to matriculating through college as a single parent, graduating summa cum laude from my community college, going on to the University of Michigan in Ann Arbor, graduating cum laude, and then going on to Michigan State University College of Law, graduating, having been on the Dean's List, moot court board, and things of that nature. I've given my high school commencement speech, as well as my Black Celebratory at U of M commencement speech, as well as my law school commencement speech. And that's because I'm a leader, because I'm a hard worker, not because I'm the smartest person, but because I'm the most hardworking person. And so that's one of the things that I think you all should know about me and remember about me as we look at who to vote for in the city of Flint for the City of Flint District Court Judge. Thank you, Judge.
Thank you. And our last presentation will be made by Mr. Torcio Feaster.
Good afternoon, everybody. Glad to be here today to be able to be a part of this forum. Most of you already know me. I've been a member of the Bar Association since I've been back in Flint for about 14 years, a little more than 14 years. I've been active in this community. I have been on the board via the Mallory Van Dyke Scott Bar Association, their seat on the board. So I've been active, I've been present. I do have a platform that I am running on. The main platform piece that the Bar Association should be aware of is that the city of Flint obviously has unique challenges. And we need people on the bench who are going to be able to address those unique challenges. And one of the issues in my platform is the need to have our leaders in this city work with our youth. We can't have our judges just do their job in the courtroom. We need to have our judges active in this city of Flint community. That's what I've done for the past 14 years, and that's what I will continue to do when I win this election. I am looking forward to being a part of the bar and continuing to do, as Tina knows, whenever Tina calls me and asks me to do something for the bar, whether it be coaching moot court, moot trial at Northern or Northwestern, or whether it be writing an article for Bar Beat, I'm right there. I haven't given a bunch of speeches as I've gone through my education, but I have been active and I've been a leader. I've been active in the NAACP in college and other groups. I created organizations in law school. the Civil/Human Rights Law Society, the Leaders in the Community Law Society. And being back home, I've been active as being president, 3-term president of the Mallory Van Dyne Scott Bar Association. So I have been very active in this community serving, not just giving speeches. So I will continue to do that once I'm elected. And thank you all again for having me today.
Thank you, Mr. Feaster. Now, I'm reversing the order of answering the questions. Each question will have a different order. And in reversing the order, Mr. Feaster, you went last in presentations. You're going to go first in answering this question, which is, as a judge, who should you hold yourself accountable to?
People who I be accountable to as a judge are the people who elected me. They put me in office so that I can serve the interests of the community and uphold the law. I also have a duty to follow the rules according to the Judicial Tenure Commission. So if elected, I would be responsible to the people who elected me and responsible to the law. I have to make sure that I am doing things appropriately as are mandated for a judge through the judicial canons and through any other law that mandates how we're supposed to act. And so that's who I would be accountable to if elected.
Thank you. Ms. Marsh, would you answer that question?
Yes, Judge, are we limited to 2 minutes for these questions as well, or just
Yes, ma'am.
less than 2 minutes? Okay.
Yes, ma'am.
I agree. Okay. I agree that as a sitting judge in Genesee County, the city of Flint, that I would be accountable to the residents of the city of Flint. I also am not opposed to taking input and insight from the bar. I know very well what it's like to be in private practice. I know very well what it's like to have to juggle the responsibility of being in multiple places at multiple times. That would not be lost upon me. I understand what it's like to have to be in district court at the same time you're scheduled to be in circuit court and then have to go back down to district court. So I'm always open to input from other attorneys as well as other judges. Obviously, come January, if I'm elected, I will be the new kid on the block. So I understand that being susceptible and open to input from other people is extremely critical. So I'm willing to be accountable to the residents of the city of Flint as well as the attorneys and other senior judges.
Thank you. Judge Hammond, answer this question, please.
Thank you. And I would echo actually both what Attorney Feaster and Attorney Marsh have said. I think they both hit the nail on the head on the people who we are accountable to. And I would add, as a judge, you're accountable to everyone. You're accountable to the people who are in your courtroom, whether they're represented by an attorney or not. You're accountable to the attorneys that appear in your courtroom. You should be held accountable to your fellow jurists, to the JTC, of course, and to the voters, but also to the non-voters. I mean, there are some people out there who they're not electing us, they're not participating in that process, but they're still a member of our community. They still may appear in front of us, and we still owe them that dedication. Anyone who comes into this courtroom gets treated with fairness and respect, and we owe that to every person, with or without a law degree, that is in front of us.
Thank you. Judge Marable, do you choose to answer this? Go ahead.
Sure, I'm gonna answer this. How much time do I have?
2 minutes.
Legally, the voters and the Michigan Supreme Court and the JTC is the answer to that question. The other questions on the questionnaire, brief description of background, it's on my website. Areas I've practiced, it's on my website. The hate crimes question, First Amendment control, but hate crimes are generally valid unless successfully challenged. Primary purpose of bail is governed by court rules and statutes. Do you believe a judge should report attorney misconduct? Yes. Ethical dilemmas, 20 years worth of ethical dilemmas have to be resolved. Have you been the subject of discipline? No. Greatest strengths and weaknesses, 10 words. I've been a judge for 20 years. What do I see the role as ADR? I use it all the time when I think it's going to help. You can also look at the League of Women Voters website What time should you take the tent? It depends. Those are the answers that I am giving you for the questionnaire. And I'm going to yield the balance of my time and say, have a great afternoon, everybody. I got to go see my mom.
Thank you, sir. Then we will turn the microphone over to Mr. Christensen.
Thank you, Judge. Well, I agree with everybody else too. We have a duty to follow the Constitution. We're absolutely accountable to how the Constitution is written and all of the laws that we have and the statutes that we have to follow, as well as the public. And I think that was well said by everybody else. So difficult when you go last on this order because everybody has already had a good answer and you don't want to reiterate what everybody else said, but it was accurate. So I think we have a duty to the public as well. And I think that's how we absolutely have to be accountable. So.
Thank you. Now, Judge Hammond, you are going to go next, and I will read this question to you. Imagine you are presiding over a case where opposing attorneys are not getting along, where they're accusing each other of inappropriate conduct, and where the discussions are rarely focused on the substance of the case. What technique would you use to diffuse these tensions and focus the attorneys on the merits of the case? What would you do?
Well, Judge, I actually, in a situation like that, I have very specific training that allows me to diffuse those type of situations. I'm a certified civil mediator. I've helped the CRC with volunteer mediations for a long time now, and having that training and being able to use that training on the bench, I think is an invaluable tool. And that is the kind of training that I would use in a situation like that. Whether it be having a sidebar or maybe even taking the attorneys, into my office and speaking with them, trying to help them realize that we need to focus on the issues at hand. We need to focus on the case, not the animosity between the two attorneys. And sometimes that happens. We've seen that happen. In court, when you're a litigator and you're in court every day, you can sometimes see the tensions and you can feel the tensions between the two attorneys, and you can see things digressing a bit into their problems with each other rather than the issues that are on the case. And so I would actively use my mediation training to try to help them come to an agreement, if nothing else, to try to focus on the case at hand rather than their feelings about each other.
Thank you. Ms. Marsh, could you answer the question next?
Yes, Judge. I would also pull the attorneys to the side and encourage them to exercise civility. Remember the old golden rule, treat someone how you would like to be treated, and to remind them that they're here representing their clients, and that that type of disruptive behavior isn't doing them any justice, isn't doing them any good. We need to focus on the reason why we're here. I'm sure everyone wants to have these proceedings proceed in a timely manner, and arguing and bickering needlessly back and forth doesn't help us to move this case along in a timely and efficient manner. So I would try to focus them on on the reason why we're here, on how they should treat one another, and how to best represent their clients. That would be my focus.
Thank you. Mr. Christensen, would you answer that?
Thank you, Judge. It's a person who's participated for at least 15 years with the Inns of Court. This is one of those things that we review on a regular basis. Inns of Court is focused on professionalism, civility, and ethics. And I think it's helpful to be reminded of that. And so if I were the judge and we had people not getting along in court, I think the first step would be some type of a reminder that we are in court and to honor the decorum of the proceedings before everybody else. And then if necessary, the private admonishment at the bench or in chambers, something like that. But to be honest, here in our area, we have a really, really good, strong bar that, don't get me wrong, there's always a few where the emotions get ahead of everybody else. But for the most part, I don't see that happening all the time around here. And I would hope that that trend continues, is that we have more civility and professionalism especially when we're on the record representing our clients. Even though we do get a little bit emotional at times, I hope that we remember that that's what we're there for, is to pursue our clients' objectives.
Thank you. Mr. Feaster, would you answer the question, please?
Yes, thank you. As Chris said, I'm also on the board, the e-board for the American Centennial Inns of Court. And so, like you said, we do a good job there of learning how to deal with and encouraging attorneys to act with civility. And I agree with him also that in this county, attorneys generally do act with civility, and you don't see these kind of actions very often. But if I did have that in my courtroom, the first thing I would do was I would ask the attorneys to approach the bench, or I would ask them to come back in the chambers. I would articulate to them that we are not going to have all this fighting if it's not benefiting your clients, it's not getting us to the merits of the case. And I would ask them to tone it down. So we would definitely have a come to Jesus moment there. And if it continued, then we would do whatever it was we had to do, whether it be admonishing them or sanctioning them or whatever is necessary. But I would definitely let them know that in Genesee County, in City of Flint District Court, that's not how we're going to act. And I'd encourage them to act with civility.
Thank you. Judge Marable, do you wish to answer this question?
He left.
Well, I'm giving him the opportunity just in case. Apparently, he's no longer here. So I'll go to a question which is based on local circumstances for all of you. And that deals with court organization. As you know, there's a national debate about court packing right now. And then locally, we've had discussions for years now about court consolidation. Specifically now, the question is, should we consider closing out county district courts and moving all the courts downtown? Now, the question is, do you think the out county court locations are still important? Or should we consider a different model to deliver justice services? And the first person that will answer this question will be, well, Mr. Christensen.
Thank you, Judge. Well, this is an interesting question, because on the one hand, economically speaking, the outlying courts are significantly expensive. And so looking at it from that point of view, that's a tough call. But if you look at it from the people point of view, then I think they're absolutely necessary. I'll give you some good examples. In our practice, we absolutely handle district court matters all around the county. Landlord-tenant matters, some misdemeanors, civil infractions. And for this is a pretty big county. It'd be terribly inconvenient for the public, for the members of the public, to drive in from, say, Fenton to handle their dog license ordinance violation case in downtown Flint. I could see where the economic side makes sense for the county, but I think for the people, we have to consider whether or not it makes sense. And I think the convenience and having the ability to have a district court regionally, maybe not as many, maybe some consolidation there might make sense, but I think overall, I think it is a good thing to have courts spread around the county. I think it's better for the public. Not necessarily better for us. It's more difficult. As some of the other candidates have said, it's hard to be at more than one place at one time. It is difficult, but this isn't for us. This is for the people. And so I think in that regard, if there's going to be any consolidation, I would hope that it would be minimal.
Thank you. Ms. Marsh, would you answer that question?
Yes, this doesn't necessarily impact the City of Flint District Court because the location is the same either way. But I do think that it's important to maintain the out-county courts because of the access to justice. It's important that the public be able to access the court systems. Everyone is not able to get downtown Flint to be able to get to the courthouse to file things, to attendance at court. Everybody just doesn't have the same resources. Everybody doesn't have transportation. It just makes things a little more complicated for the people who are residing in the out county. And I think that having the courts spread out throughout the county, as we do now, is important to making sure that the residents in the out county have access to justice, access to the court system. So I would weigh in favor of keeping the out county courts open.
Thank you. Mr. Feaster.
Thank you. I'm generally against consolidation. Obviously, as a Flint resident and being running for a Flint court, Flint's already suffered a lot of that as we were absorbed into the county, as Flint has already lost a judicial seat. So I'm obviously generally against consolidation. I would need more information about the economics in order to be able to give a good answer to this question about how much we're paying for out county courts, how that affects the downtown court, what the numbers were in terms of the populations who go to those out county courts as opposed to come downtown. So I think a lot more information would need to be provided for me to give a good answer to this question. But as Chris said, and Attorney Marsh said, you don't want to make it difficult for people in those local jurisdictions to have trouble getting to court. And so if that's going to be a problem, and that's outweighed by the financial circumstances, then I would obviously say keep them open. But I need more information to give you a really good answer on this question.
Thank you, Judge Hammond.
Thank you. This is something that I've actually been talking about for a while and am really dedicated to the idea of keeping the out county courts open. As other people have said, it's not about us and it's not about the attorneys, it's about the people. And it's about the people in the out counties being able to have access to the courts and access to justice. You know, my jurisdiction here in Burton, there are a lot of people who don't have vehicles. There are people who I know walk to this court, and they need a local courthouse that they can come to so that they don't have to go all the way to the center of this county. And as Attorney Christensen said, you know, even people from Fenton, people from Clio, you know, these people need somewhere local that they can go so that they can have access to the courts and access to justice. And so I will continue to fight to keep the out county courts open because I think it's important for the people that we are here to serve.
Thank you. Ms. Hammond, I think we'll have you start with the next question. As human beings, we're all subject to the influences of bias and sympathy. And I'm wondering what you would do as a judge to set aside your bias and sympathies so that all parties can be assured that they're receiving unbiased rulings and unbiased treatment. What would you do?
Well, and it's a question of what do I do also, right? Because we have to do that every day. And I don't feel like I have a whole lot of biases or sympathies or empathies or whatever towards people who come into my courtroom, because as attorneys, we're already trained to set that aside. We're trained to come in, look at the facts, take away all of those extras, put them in a box over here, and analyze the case. And it's just the same when you're a judge. You have to be able to take these things, put them over here, and just look at the case that's in front of you. Now, what I will say about that additionally, though, is that you always want to make sure that everyone in your courtroom is comfortable and believes that you don't have any type of bias or preconceived notions or anything like that. And I did have a situation not too long ago where I had represented a man in a custody case, and it was a very difficult case. And the opposing party, the mother, had come into my courtroom. She didn't recognize me. I had a mask on, but I wanted her to know that I knew who she was. And I gave her the option of transferring the case to a different judge because I didn't want her to think in any way that I would rule differently. And I don't think that I would have, and explain that to her, that I didn't feel like I was biased anyway and I could hear the case. But I don't ever want her or anyone else walking out of my courtroom thinking that maybe I wasn't. So I think we always need to keep that in mind. It's not only, you know, it's the appearance of impropriety. It's the appearance of maybe there might be a bias, and you just don't want anyone in your courtroom feeling that way ever.
Mr. Feaster, would you answer the question?
Yes. I live by the creed that Dr. King taught us. but we're trying to judge people by the content of their character and not by any other means. So to me, it wouldn't matter if someone is, it doesn't matter if someone is black, white, young, old, tall, short, male, female, or other. That just doesn't matter to me. I'm here to try to help people. I have been in my defense practice as a criminal defense attorney to try to help people. And it doesn't matter any of their background or their economic status or any of those issues. My goal is to help people as a defense attorney. And as a judge, obviously, I would try to set aside any biases I may have for any cases that will come before me. I don't believe I have many, but obviously people do have biases. And if I noticed I had one or had any, I try to set it aside. But I don't believe that'll be a problem. But as Judge Hammond said, if there was an appearance of impropriety, the rules, the canons mandate that we avoid those, the appearance of impropriety. And so if I needed to recuse myself for any reason, then I would do that. But I don't believe I'll have that problem when sitting on the bench.
Thank you, Ms. Marsh.
I also don't think that'll be much of an issue for me, but sometimes you don't know what you don't know. And so that's why I think it's important to have implicit bias testing and implicit bias training to see if you do in fact have a bias that you're not aware of. That's another reason why I think that it's important that we have judges on the bench that are representative of the community that they're serving. For example, currently in the city of Flint, on the district court, there are no women serving whatsoever. We have a bench of 4 men with no women. And then when we look at the Genesee County District Court bench as a whole, there are no African-American women serving. There has not been an African-American woman serving on the district court bench since 2017 when Judge Tracy Collier-Nix retired. And so I think that if we have a bench that's representative of the community is serving, we can help eliminate some of the bias that may be there. But I also agree that we should not have, that we should avoid the appearance of impropriety. And if as a judge, you know that you have a bias for one reason or the other, you should recuse yourself and pass the case along to a different judge to avoid that appearance.
Thank you. Your turn, Mr. Christensen.
Thank you, Judge. Well, it's interesting. I believe all of us have some sort of bias of some type. And Tabitha, Ms. Marsh mentioned implicit bias. And for the State Bar of Michigan, they had us attend an 8-hour class taught by a very, very well-known lady who teaches implicit bias training. And so we learned a whole lot about implicit bias. And it was an amazing class. And so I think one of the keys that we have to do is be cognizant that it exists and cognizant that it can exist in us. And so I think as you go forward and you consider cases that may come in front of you, that you have to be aware of that and then take proactive steps if you think there's something out there. I do agree with some of what was already said, that some of us, and especially doing criminal defense here in our area, we come in and we don't have preconceived notions. We want to try to help the situation, try to evaluate the case and move forward as best we can without regard to any of those type of details. We want to just try to help. And so I think being aware of that and being cognizant that there's things that could arise, obviously I can't foresee exactly what might arise, but being aware that there's something to be paying attention to is important to making sure that we take corrective steps.
Thank you. And Judge Marable has left, so I cannot ask him the question, but I'll go back to you, Mr. Christensen, and ask you a different question. What would you do if you were asked to make a ruling using a law you disagreed with?
Well, the beautiful part about our level is that we have an obligation and a duty to follow the precedents that are laid out before us. We don't have to agree with them. And there, I'm sure, will be case law in instances where I do not agree with them. In fact, I know there are, because I've appealed things myself already as a 20-year practicing attorney, where I've ran into a case that I absolutely disagree with how that case turns out. And so I've had to make my record and take it to the Court of Appeals. I've had the benefit of going all the way to the Michigan Supreme Court and fighting against one of the largest law firms in the state of Michigan to try to argue about some old case law and a statute and how that statute is interpreted. So that question to me is very easy. At this level, I am duty bound to follow the precedent before me. Now, I might be able to articulate that am obviously following what I have to follow and that I'm not necessarily a fan, but my personal opinion, just going back to the last question, unbiased, my personal opinion doesn't matter. Right now, I have a duty to apply the law that is before me based on the facts that are before me. So I would follow that edict.
Thank you. Ms. Marsh.
I completely agree with what Attorney Christensen said. As jurist or a future judge, my responsibility would not be to legislate or to make law. Even if I don't agree with the law, it's my responsibility to follow the law. And I think that if a candidate wants to change the law, then they need to run for state legislature as opposed to running for judge. So our responsibility would be to absolutely follow the law, follow the precedent, follow the law as written, and not to, whether you agree with it or whether you disagree with it, that's your responsibility as a judge.
Mr. Feaster.
Thank you. The law is the law. I mean, this is not, unfortunately, the United States of Torso. I don't get to do what I want to do. I'm not a dictator. So if the law is clear and the facts of the case are clear in line with prior case law and precedent, then you have to follow that law. Like Chris said, I may make a record that I disagree with the law, but I would definitely apply it as it is written. And as the judicial canons say, I guess I disagree with what was said previously. The judicial canon suggests that a judge is in a unique position to be able to advance the law. And so it is our job to work with our state legislators and other people, the way I read the canons, to try to help advance laws that are badly written or poor laws. I've done that as a defense attorney, working with Phil Phelps to try to broaden the expungement law. I've spoken to the governor and lieutenant governor about the expungement law, and I am so thankful to see that that was changed. So I believe that judges need to use their influence and their knowledge to be able to help fix laws that are unjust. So that's my position on that.
Thank you. Now I'm going to ask one last question as moderator, and then I see that we've gathered up about 7 chat questions, which we can go into. The last question will go to you, Ms. Marsh. How can you cause respect for authority? What can you do to have the people, the citizens, respect our institutions as we want them to?
I think it starts with reaching the youth and reaching the young people and teaching them at a young age the importance of respect, the importance of honor. It also is a matter of how we treat other people. If we treat other people badly, then they're going to think it's okay to treat someone badly. So as judges, as attorneys, as leaders in the community, it's our responsibility to model the type of community that we want to see. And so I think that we, in how we treat other people, we're teaching them how to treat other people. And in training up the youth and teaching them honor, whether it's mentorship programs, whether it's speeches at the schools, whether it's other type of programs that we can have where we teach them the significance of honor and respect. And first of all, being the model that we want other people to see.
Thank you. Mr. Feaster.
Can you repeat the question, please?
How do you teach the citizenry to respect authority? How do you re-instill in them respect for authority?
Okay. Well, obviously you need to work with the people, but in order for them to respect authority, they have to feel as if the authority is respecting them. And so we have to have transparency and open dialogue so that the people, especially in the city of Flint, feel as if they're being heard. Oftentimes, they do not feel like the justice system, as you can see by all the social unrest we have right now in this country and in this community, is hearing our residents. And so if we can show them, if we can have that transparency and we can show them that the justice system cares about them and respects them, then our citizens will then respect the justice system. But as long as the citizenry, the people of the city of Flint do not feel as if this justice system, law enforcement respects them, then it's going to be hard for us to get our citizens to respect the courts and the law.
Thank you, Mr. Christensen.
Thank you, Judge. You know, I think we've all said that show respect and follow that, but that really boils down to leading by example. I think leading by example from the bench is showing consistency, but it's also something else that I think we need to focus on a little bit is listening. We need to do a better job of listening too, so that we hear what some of the concerns are. But then moving forward, I think we need to establish that the court is part of the system that needs to be respected and will be consistent in what it does and its applications of how we proceed. I'll give you a good example. There's a judge who recently retired that everybody knew they had to be there at 8:15. The reason why was because it was consistently done at 8:15. There was no messing around. You knew. You planned your day around it because you had to be there. The public knew that. I had clients that knew that. Everybody knew it because it was consistent and it was over and over and over again. And I think that leading by example is something that I think people pick up, they understand. And that's how you get people back to respect the authority of the court, is by making sure that it's been earned and that it's followed through, and that they're going to have a fair opportunity to be heard, but at the same time, they have to respect the court in order to have that fair opportunity. I think that starts with us leading by example.
Thank you, Ms. Hammond. Judge Hammond.
Thank you. And no, I agree. Again, you know, I feel like us all answering these questions, the four of us seem to think very similarly, and that's a good thing for the people of Genesee County. But you have to show people respect in order to expect respect. I think we all know that. And when people are in your courtroom, you have to show them a certain amount of respect, whether it's an attorney or a litigant on their own, in order for them to feel like they've been heard. And when people feel like they've been heard, they feel respected. And then they don't usually have a problem showing the amount of respect that is required when you're in a courtroom or anywhere else for that matter. I always try to make sure when people are in my courtroom to make sure they know that they've been heard. And then to make sure they know why I'm doing what I'm doing. I don't just hand down a ruling with no explanation. I explain to them why I'm ordering them to go to anger management, or I'm ordering them to go to some type of treatment program or something along those lines, because, you know, I feel that you need it, and let me explain to you why. And I feel like then people walk out of the courtroom, they feel heard, they feel respected, they show respect to you while they're there, and then they show respect to you while they're out in the community talking about you. So.
All right, those are the questions that the moderator poses. We also have questions from general membership. Mr. Brickley, Mr. Piper, pick out a good question for us, would you please?
All right, well, here's one from David Layton, our prosecutor. And he asks, because of COVID-19, Michigan Supreme Court Order 2020-6 requires all judges in Michigan to make a good faith effort to conduct proceedings remotely whenever possible. In light of that order, when is it necessary for judges to physically be in the courtroom and require lawyers to physically be in the courtroom?
Ms. Hammond, you get to go first.
Thank you. Well, my policy has been that if testimony is required, then people need to be there. So if we have a preliminary exam, or if it's a civil case where testimony is required, then we need to have the witnesses there. We need to have the attorneys there. And that rule in my courtroom anyway is due to the fact of being in private practice, being a defense attorney, and knowing that, and even working, you know, I interned for the prosecutor's office. All of us as attorneys, we need that interaction when we're taking testimony. We need that interaction. We need to be able to see the witness, really engage with the witness. And that's so hard to do via Zoom. I think that someday we may get to the point where we can do that, but I don't think we're there yet. So anything that requires testimony. And then as far as other hearings too, you know, I give the option of appearing via Zoom or appearing in the courtroom, because we have to remember there are some people that can't appear via Zoom. There are people that live in my district that don't have a telephone that is capable of Zoom hearings, and they don't have a laptop, and they don't have a computer, and some of them don't even have an internet access at their home. So we have to keep that in mind following SCAO's orders. But you know, we're all still learning from this process, and I think that the technology is going to be extremely helpful in the future. I don't ever plan to stop using it. It's really convenient for attorneys. But when there's testimony, I'm still not sure how we do that unless it's in person.
Mr. Feaster.
Yeah, that's a great question from David. And I wholeheartedly agree with what Judge Hammond just said. And I will, I'll echo that. In fact, I made a big deal about this back in April when I made a video that's on my website, feaster2020.com, stating that judges who were requiring defense attorneys to conduct preliminary examinations via Zoom, I felt was unfair and unjust and disenfranchised and hurt my client's ability to have a good and fair hearing. And so as a result of that, I got off the court appointed list because I was not going to continue to conduct exams via Zoom. I felt like it just was not an appropriate tool for being able to appropriately defend my clients. And so I agree with Judge Hammond that if something does require testimony back and forth, and you need to have your client next to you to be able to go through things, it needs to be done in a courtroom. But there are so many things that we can do via Zoom, whether it be pre-trials or simple sentencings or simple pleas, or a lot of things we can do via Zoom. And I hope the judges continue to use it. But like I said, I wholeheartedly agree with Judge Hammond that not everybody has Zoom. Not everybody has internet. And so we cannot continue to disenfranchise people and hurt people and put warrants out on people because they can't get on Zoom. We have to give people the option to appear in person if they don't have those luxuries. And so I definitely agree with Judge Hammond.
Mr. Christensen.
Thank you, Judge. And while I agree with the sentiment that there has to be certain things done in person, the preliminary exam is a great example of that. I think right now we have to be cognizant that we are in crazy times, unprecedented times, and there's a serious health ramification. So I think we have to have the court be more amenable, where appropriate, to doing things by Zoom. Right now, Michigan and around the country, we're seeing the uptick in cases, positive cases, and obviously then therefore increased deaths. This is extremely serious. So if there are things that can be done by Zoom that won't infringe on anybody's rights or protections, then I think we need to take a long, serious, hard look at doing them by Zoom. A regular pretrial in a civil litigation could be done by Zoom. Summary dispositions. The problem arises is that you can't have a one size shoe fits all. I mean, you're going to have some very, very complicated matters across the board in every spectrum of what we do. And so there might need to be a little bit of a case by case adjustment. But I think in general, if we can find a way to do more things remote, at least right now, in the middle of what we're going through as a country, I think we need to make it a priority to try to do that.
Thank you. Ladies and gentlemen, we've been here for about an hour going through this process. We've had intelligent discussion. And
Judge, I didn't get a chance to answer that question.
I beg your pardon. Go ahead.
I very quickly, because I see you want to wrap up. I get it. I think that if it's a case where there's no testimony needed or limited testimony needed, that we should do it by Zoom. If it's a case where there's a significant amount of testimony needed, then I think we should appear in person. But we also need to listen to the litigants and the attorneys and see what their preference is in those circumstances. I heard someone say earlier that when the courts were conducting exams and things by Zoom, they got off the court appointed list. Well, I don't think that that's the best way of handling this situation in the middle of a pandemic when you have indigent clients that need representation. I think we need to stick and stay. We need to be flexible, and we need to work with the bar and the bench so that we can get through this together, as opposed to abandoning people that need our legal services. Thank you, Judge.
Thank you. All right. Now we will conclude this discussion and turn the meeting back over to President Tesner.
Thank you, Judge. Thank you, Bill Brickley, and thank you for our participants. And thank you everyone for attending the forum today. I hope you found it informational and enlightening as I did. If you have additional questions, I'm sure the candidates wouldn't mind if you forwarded those to them. I would also like to mention that we are currently working on planning how we can support the Flint community this holiday season and put on the community holiday dinner in some way. The committee chaired by Brian Barkey has already met. And so please contact Brian Barkey to volunteer, to donate, to share your ideas and support for this essential service that we are able to give back to our community. And unless anyone has anything else, I would declare the meeting adjourned. Thank you.
Thank you, Michael.
Thank you, everyone.
Bye-bye, everyone.
Thank you.
Thank you, everybody. Appreciate you.
Bye-bye.
Thank you.